Good afternoon all. Thank you all for joining us. It's always a shame that we can't see faces, but we can see that there are 110 of you. So thank you so much for taking the time to join Richard and myself today. So we're going to look at employment update for yourselves today. Two areas that we really want to focus on though. So this is not a generic employment update, it's really focusing on two areas, and our agenda will set that out for you. So today I'm going to focus by looking at trade unions and trade union recognition specifically. So on the next slide, which is the agenda, we'll see that we're going to look at trade union aspects. What is recognition? Looking at the types of recognition and looking at perhaps alternatives to recognition also. And then Richard's going to pick up for us and look at keeping children safe in education and the changes that we saw in the summer. And at the end, we'll take any questions then. So we're going to leave plenty of time to make sure that we've got ample opportunity to answer the questions that you might have. So I'm going to start, please, by looking at trade union recognition and what it means to our independent schools. We've seen a huge amount of increase in activity in the sector. Perhaps some of it is stemmed by those schools that are undertaking consultation in respect of changes to pensions, but that's not the only topic that's brought this to the fore. Any changes to terms and conditions of employment, where perhaps you are looking at making large numbers of changes. We have seen increased union activity as a consequence. And we've seen a number of schools now with trade union recognition. So the NEU, I've had to look this morning at the NEU website to see the number of schools that they say are recognising the NEU. 120 independent schools, they say, recognise the NEU, and that includes both teaching and support staff, so not solely teaching staff alone. NASUWT, they too are also a big union in the sector. They haven't published a specific figure, however, they do say that they support many in the independent sector. So we've seen that greater activity, so it's sensible to understand what does it mean for you? Where do you stand? Do you want to engage with the unions on this conversation? Do you want to see what other scope there is for taking a different path with your staff before the unions do come asking for recognition? So what might the tactical aspects be for you that you want to consider? So moving on to the next slide. What do we actually mean when we say recognition? So this is where the process whereby a trade union can be recognised, so they can negotiate on behalf of their members and indeed on behalf of a bargaining unit. So they can then negotiate with the employer as to the terms and conditions of employment. What is a bargaining unit? Well, they can decide. So if a union was going to approach you for recognition, they can say who might form that bargaining unit. Will it be all staff at the school? Or will they vary it? So they have teaching staff and support staff in separate bargaining units. So they can determine who they are seeking representation for. And then if recognition is granted, then they can negotiate collectively on behalf of that bargaining unit. Now, we do tend to see the unions focus on teaching staff, but that's not the only individuals that they can represent, as I say. Some choose to represent both. NEU, we've seen represent both at many a school, but it's that TPS conversation that does tend to lean towards the teachers and their added protections. Moving on. What type of recognition might we then be faced with? So you might have a request from a trade union to have voluntary recognition. So they're not following any sort of a formal statutory process here. They are coming to you as a school saying, we would like to be recognised. Now, they might have had conversations with their members in advance to see whether or not they have the support of the teachers or support staff or whoever forms that bargaining unit in advance. But otherwise, they're looking to you to say, we would like to be recognised so that we can then negotiate on behalf of those that we do form in that bargaining unit. So that dialogue can be had with you directly, and you might choose to engage in that conversation. Now, if you didn't, and the union still wanted to pursue that avenue, then they will look to the statutory recognition. they can go to the Central Arbitration Committee and they can then seek compulsory recognition. So statutory recognition and compulsory recognition, you'll hear the term being interchanged, but that's what it means, that the CAC, if the numbers are there backing the request for recognition, if the numbers are there, then they can be in place to negotiate terms on their behalf of their members. Now, what can they negotiate? Well, it really comes down to what they want to put into the recognition agreement. Under the statutory recognition process, I've set out for you there that it's in respect of pay, hours and holiday. So that's the statutory process. So that is the basic aspects that they could ask for, but they could ask for more, and we'll come on to look at what more they could ask for and what we have seen at schools. Moving on. I've set out here for you just in very broad terms what the process is. Now, we know that they can come to us, we can either accept that request and we can then proceed with the recognition, or you can reject that request. So it might be that you're not quite happy with the terms, but you are open-minded to having that conversation about recognition. So you might reject that particular one, but nonetheless engage in a degree of negotiation. But if it's rejected outright, then the unions can move to the statutory process. And the statutory process is making that application to the CAC and getting the CAC involved in assisting, whether it's that we don't agree with the bargaining unit. That's perhaps less the case in independent schools and schools more generally. The bargaining unit will either be all your staff or teaching and supporting separate bargaining units. They might also assist with that ballot process, but ultimately, whether or not the union will be recognised will be a matter for the CAC to determine. Moving on. What sort of timescales are we talking about here? When you are approached, if you are approached, actually we can lose track of time quite quickly because the timescales aren't particularly vast. So if you had the union come to you making that voluntary request, then you've got 10 days, 10 working days in which to consider it. Now, if you were going to say, well, I'm not quite content with that, so I'm going to reject that particular request, but I am going to negotiate, then you have a further 20 working days. So that's tagged on immediately after that 10 working days. So it is quite a tight time frame. Now, if you wanted some support, some mediation, then ACAS is going to be there to support you as well. And we've got some further time frame there. But then you can see how the time does start ticking away when you start moving through the formal process if you're not going to reach agreement. So if you do get that request, it's best to really work on it immediately, get some advice immediately, so you can decide, is this something we want to accept or not? And if not, on what basis? And if we are going to challenge this, even when it gets to CAC, how are we going to challenge it, or what options are available to us? So moving on to the next slide. Now, if you do have a ballot for statutory recognition, then the unions will tell you who encompasses that bargaining unit once again, and then they will let you know that they are going to ballot those individuals. So they will then have to ballot their members at the school. So you have to have a majority of those that are voting have to vote in favour of recognition. And then of that, you must have at least 40% that are going to encompass that bargaining unit who also support. So for example, if they were going to ballot the entire membership, and they say had 100 staff, of that 100, if we say we had 40 who are teaching staff, then those 40 have to say yes to that bargaining unit. Now, if they are successful, then you could draft up a recognition agreement. Now, if you're going through the statutory route, the CAC will provide that recognition agreement, and you will then be able to say, but you have a limited say as to what you agree to or not agree to in that agreement. So if you feel that your staff really are going to press for recognition, it's far better that you engage in that voluntary process, because you'll have greater control over what is in the document. Because once you get through to the statutory recognition route, that control is really taken away, and the CAC will provide their statutory recognition agreement, and there'll be limited opportunity to negotiate on its terms. So pay, hours and holiday again. Now pensions. Now I'd imagine the unions will really press for pensions to be included. At the moment, the statutory process doesn't actually include pensions, but what the unions are saying is that actually pay, we can't deal with pay in isolation. Pensions has to be included because the remuneration package very much incorporates pensions. So do have a look, do see what they are pressing for. Now, I don't really particularly mind if my schools decide that they want to incorporate pensions. Indeed, I'm not really worried whether or not the unions press for recognition, because actually, where we have seen the unions involved, you can have greater dialogue, and you might be able to have greater time with those unions. Now, when you are, say, negotiating on changes to terms and conditions of employment, and you're affecting 20 or more colleagues, then you have to go into collective consultation. That means allowing those who are affected to appoint representatives who will then engage in the process on their behalf. That means time out of teaching, for example, or you're asking them to do the meetings at the end of the day. So there's a lot of commitment there on behalf of the individuals who are acting as representatives, whereas you could potentially be having that dialogue directly with the trade unions, and you might have then, they will have a broader understanding of what's happening at other schools perhaps. So it's best to understand, where do you think the conversation sits at your particular school? Because some will say, well, that's all well and good, but actually they don't understand the ethos at my particular school. So that's why I would far prefer to have the dialogue with my staff as opposed to trade unions. So moving on. What we have seen encompassed in other collective agreements, the far broader collective bargaining powers. So it not only includes those statutory pay, hours and holidays, but goes further to look at disciplinary and grievance matters. Health and safety does very much tend to encompass one of those duties upon which they can consult on behalf of their members. Redundancies, if that's going to occur, and also looking at professional development as well. Now, the point to bear in mind here is that this is a collective bargaining right that they have. So let's say, for example, if you were going to vary terms and conditions, say, of a few colleagues. So if you had term time only staff and you were going to change their allocation, you're still able to have that engagement with staff directly. Collective bargaining kicks in where you're going to affect terms and conditions for more than 20 colleagues. So don't think that you've lost the opportunity to speak directly with your colleagues, because that won't be the case. But you do have to understand when the unions have the right of consultation. So moving on. Now, working with trade unions comes up time and again. Now, we always say, look, use this opportunity to really occupy the space. It's far better that you lead any conversation. So that communication, how you go about holding those collective meetings, are really going to form part of that recognition agreement. And it will really contain the level of detail, such as the number of meetings you hold, who will be in attendance on behalf of the unions, who will be in attendance on behalf of the schools, will the governors and trustees be involved, and if so, how many and at what level? So there's going to be a huge amount of prescriptive detail in that document. So far better that you start with your own recognition agreement as opposed to ones that the unions might provide you. Because the ones we've seen, of course, you'd expect it to favour the unions if it's coming from them. One that we have prepared is very balanced. It does really look at the statutory agreement and then tailored that to work for our independent schools. But setting out that expectation, ensuring that the right is there for the school to determine ultimately what terms and conditions are implemented, and you want to make sure that that is very much reserved to the school ultimately, albeit you will engage in consultation with a view to reaching agreement, but that's what it must be. Now, you will have trade union representatives within the school amongst the school staff. So just be mindful how you're interacting with them if they are the representatives on behalf of the trade unions, because what we don't want is any allegations of detrimental treatment because of their trade union status. Now, when you have colleagues acting as representatives, they're in a quite protected position, and we have seen many an allegation, quite unrelated, but then is perhaps manipulated to say it's as a consequence of my trade union activities, not my performance, say. So do be alive to those particular issues. And also, if you do have colleagues who are representatives, your obligation may well be first to the trade unions to notify them if you do have any concerns about any specific individual, particularly if it leads to a capability, disciplinary, etc. So that's how really best to work with the trade unions, but getting that core fundamental documentation is absolutely key. Likewise is the quality of the communication and that is undertaken at those meetings. Moving on to the next slide. Now, what we've spoken about so far is recognition agreements. Now that's very formal in negotiation and dialogue with the trade unions. But what if you wanted to preempt the fact that there could be future activity at the school, whether that's changes to terms and conditions, whether it's broader discussions about changes to the school curriculum, which might then impact terms and conditions? Might you want to preempt some of that? Might you want to put in place your own way in which you can consult and inform your colleagues? You can do that under the Information and Consultation of Employees Act, and that's all about regulations, beg your pardon. And from there, you can put together what is an ICE agreement. It's a voluntary agreement with your staff. So the staff will elect representatives with whom you would then engage with discussion. But could it be an alternative to recognition? Whilst it has similar formalities in how you would engage with the staff as opposed to trade union representatives, you've got that degree of control. Would it help your staff? Would it help your common room to engage them in a more collaborative way, perhaps? Perhaps we have some common rooms that might not feel that they're really involved in what the school's plans are and what the strategic plans are. Might it enable you to facilitate that dialogue? So if you feel that you need an avenue in which to have those conversations, ICE agreements shouldn't be forgotten. I think whilst again it's quite a prescriptive formula as to how you set one up and the meetings etc. that you have under it and how you go about electing representatives, you do then have a body through whom you can consult. So if you are going to go through any changes to terms and conditions, you can use that avenue. You don't have to go through further election of staff representatives, for example. So if that's an avenue you'd like to consider, then have a look at the information and consultation agreements. We've also have one that we can share with you if you are considering this route, but it might be one where you can then circumvent the need for the trade unions by saying, well, actually, no, we have a really great working ICE agreement here and our staff are quite happy with it. And far rather you have that engagement directly with colleagues as opposed to the unions. So moving on, that should take us to Richard, who will now talk us through the changes to keeping children safe in education.
Thanks, Naseem. Yes, I'm going to have a brief look at some of the changes that came into force in the September 2021 version of KCSIE. Just a bit of background for you. So we had a consultation version of KCSIE published between December last year and March this year, which everyone I think got fairly familiar with the changes that were going to be in there, in particular in part 3. The new version, the current version, was published in August and was quite different to the consultation version, which was unhelpful, but not necessarily unexpected. And obviously that version is now coming to force on the 1st of September. So you've not had a huge amount of time between that being first published in August and coming into force in September 2021 to get to grips with the changes and to implement them. But hopefully you're all starting to get used to the different parts of KCSIE now. But I can say we're certainly having a lot of questions about different parts of it. So we'll cover some of those for you today. As I'm sure you're aware, there are lots of changes to Part 3. There were no new recruitment checks as such, but much more detailed guidance on the recruitment and the selection process. And that mirrored what was in the previous safe recruitment guidance, so safeguarding children and safe recruitment in education, which was in force for 7 years before KCSIE came into force. So there's now that section which looks in more detail at advertising of jobs, application forms, shortlisting, references, and then the interview and selection process. As I said, that sort of detail was all in the previous guidance, and we found that quite sensible and couldn't quite understand the rationale for taking that out of the safe recruitment guidance, and we therefore took a decision to retain much of what was in SCSRE in both our safer recruitment pack and our safer recruitment training. So a lot of our documentation was largely unchanged when this new version of KCSIE came into force. And I mentioned safer recruitment training at the bottom there. Not that it's a change in KCSIE, but that I think it's now a very important time to refresh or to do safer recruitment training for the first time, because these are the most significant changes to the safer recruitment section for several years. So if you hadn't had a chance to do any training, I'd recommend that you look into doing so. If I could have the next slide, please. Just a bit of new wording right at the back of Part 3 of KCSIE, which I think is it has some important messages for schools to consider, and it's just about considering safer recruitment and safeguarding as a whole school responsibility. So safer recruitment is not just about carrying out the right DBS checks. We get lots of questions about, can someone start work because they have had a DBS check or they've been able to provide a really old one. Safer recruitment's about a lot more than just criminal records checks. It's about a whole range of background checks and a process that's aimed at determining whether a person is suitable to work in a school with or around children. It goes on to say that safeguarding then is not limited to recruitment procedures. So that is, from an employment perspective, establishing a safe culture and vigilance amongst other staff, so that behaviours that sort of breach your culture don't go unnoticed and are properly dealt with. And then the good start, safeguarding requires a continuing commitment from governing bodies and proprietors and all staff to ensure the safety and welfare of children is an embedded message in your school's ethos. So it's really emphasising that it requires a whole school coordinated approach to safeguarding. On the next slide, please. Just wanted to mention some of our resources that are available for you. So hopefully many of you are familiar with our safer recruitment pack and our safer recruitment updates, which are all made available on our website, Independent Schools on Stream. We also send them out by email, and those are all available free of charge. So it's a good free resource for you to use. We do safer recruitment training, which is considers these issues that I'm talking about today and many others in much greater detail. And we're now doing in-person sessions again. And we also do a single central register training, which really looks at the pre-appointment checking process and how to maintain the SCR in quite some detail. So that's an online session that might be of interest. Moving on to the next slide, please. So just moving back to looking at KCSIE and some of those key changes. So firstly, safer recruitment training. There's a change in emphasis here. The previous versions of KCSIE all said that safer recruitment training had to cover, as a minimum, all of KCSIE, which we always found a bit odd, given that it's only Part 3 that covers safer recruitment. But we still focused our training on all of the parts of KCSIE. It's now changed. That's the wording, so it just needs to cover Part 3 of KCSIE, which we found helpful because it allows you to focus much more on the recruitment process and then to bring in those other parts of keeping children safe education as they relate to safer recruitment and the ongoing the ongoing culture and ethos with which staff are employed. There's then new wording on job descriptions and advertising, all of which was in safeguarding, safe recruitment, safeguarding children and safe recruitment education, the previous guidance, and has now come back in. I think this is all pretty helpful stuff. So firstly, with the job description, there's just some wording about what it should contain and what you should be looking to achieve. So firstly, the skills, experience, and attitudes and behaviours you're looking for from a particular person. So that's looking at the sort of the employment aspects of a job description and a person specification. But then looking at how those people's behaviours and attitudes relate to safeguarding, and also specifying the safeguarding requirements of the role. So, for example, how much contact with or responsibility for children would the post holder have, and also then will the role amount to regulated activity with children. So those are all new aspects to consider. So do check your job descriptions and person specifications cover all those areas. What I would say with that point about regulated activity is that pretty much all roles carried out in a school on a regular basis, so once a week or more on an ongoing basis, will amount to regulated activity. So you can be almost 100% sure that the role you are recruiting for will amount to regulated activity. Moving on to look at advertising. Sorry, it's on the previous slide. If I go back to the previous slide. Thank you. So advertising there, paragraph 193 of KCSIE. So this is new wording again, and specifies what should be included within your advert. So make sure you're including all this wording, and it won't be a hard thing for inspectors to check whether you're complying with this, simply having a look at the adverts you publish. So your job advert should contain wording on the school's commitment to safeguarding and promoting the welfare of children. The safeguarding checks will be undertaken, and then the safeguarding responsibilities of the post. So what we've got there is this commitment at an early stage to safeguarding, almost to warning potential applicants that safeguarding is taken very seriously at this school. And if you want to apply for a post here, then you should do so in that knowledge. It's also seen to be, specifying checks will be undertaken is considered to be deterrence at the earliest stage in the recruitment process. And we've always advised that this wording was included in an advertising policy, which forms part of our safe recruitment pack, and that was something we didn't deviate from, even when this wording wasn't in KCSIE. And then whether the post is exempt from the Rehabilitation of Offenders Act. Well, as I mentioned, all roles within a school, almost all roles will amount to regulated activity, and all work which is regulated activity is exempt from the Rehabilitation of Offenders Act. So again, you can be fairly certain that the role you're advertising for will be exempt from the Rehabilitation of Offenders Act 1974. I should also mention that having to include this wording in your adverts is of course going to increase the length and the cost of those adverts. As I said, this wording used to be in the previous guidance, and we used to get a lot of questions about, well, do we have to include this wording because it's going to increase the cost of our adverts? Can we not keep this out to keep the cost down? Well, unfortunately, cost has never been a good reason to depart from statutory guidance, and therefore we advise that you do include this wording in your job adverts to comply with KCSIE, but again, also just to demonstrate that commitment to safeguarding at an early stage in the recruitment process. Could I have the next slide, please? So there have been some sort of key changes around application forms and shortlisting. The first point to note is paragraph 194, which states that you should have a statement in your application form mentioning that it's an offence to apply for a role working with children if the applicant is barred from doing so. Now that's wording we've always had in our application form, but it's interesting to see that now expressly stated in KCSIE. But the other interesting points are around the questions you can ask in the application form of all applicants and then of shortlisted candidates. So paragraph 198 states that shortlisted candidates should be asked to complete a self-declaration of their criminal record or other information that would make them unsuitable to work with children. And then paragraph 199 states that this information should only be requested from applicants who have been shortlisted, and then goes on to expressly say that it shouldn't be requested in the application form, only of those who should be shortlisted. So firstly, this is new, and many of these questions around criminal records or other suitability information were previously contained in the application form. So do you have to take them out? Well, from a legal perspective, you can still ask all applicants about their criminal record because of the role that you're appointing for, and it follows that you can also ask them any other suitability information. So from a legal perspective, you can do that, and there's no explanation in KCSIE for the statements that are made in paragraphs 198 and 199. We presume that it's an effort to give people a better chance of having their application considered if they have some suitability information to disclose, which is fine. But again, it doesn't prevent you from asking those questions in the application form should you want to. I think more pertinently, however, it's probably a data protection issue in that you should be collecting data in a proportionate way. And therefore, if you're asking this information from the widest group of applicants, and therefore from some who will not even make it through to shortlisting, are you asking for too much information from too many people? So that there is a risk there from a data protection perspective. So our advice is both to comply with keeping children safe in education and your data protection obligations, that taking out suitability questions from the application form is the way to go. On the next slide, I've just posed a couple of questions here in terms of what can we now ask in the application form. So can we ask questions about criminal records in the application form? Well, as I mentioned, legally, yes, but they're about suitability. And KCSIE wants you to move that along the process and only ask those shortlisted candidates. So to comply with KCSIE, as I mentioned, data protection, questions about criminal records should now be moved into a sort of a shortlisted candidates suitability declaration form. But can you ask questions about whether a person is barred from working with children, whether they're prohibited from teaching or management, or whether they are disqualified from providing childcare in the application form? And we think yes, you can ask those questions. And the reason is because you're asking a person to confirm whether they can actually do the role for which they're applying. So are they prevented from doing the role they're applying for? So it's not about suitability, it's about whether they can do the role. And we think you can ask this of all applicants, but it needs to be done in a proportionate way. So we have suggested doing this with a tick box only, asking for no further information if someone were to tick yes, and then encouraging them to only tick the section that's relevant to the role for which they're applying. So you're getting some limited information about whether a person can do the role, and therefore you're doing that in a proportionate way. All of the other information that's specified in paragraph 198 about suitability and criminal records can then be moved into a separate shortlisting suitability declaration form, one of which we created and now sits within our Safer Recruitment pack. Can we move on to the next slide, please? Again, there have been changes with regard to references, and we've had quite a lot of questions about some of those changes. Now, the first thing I mention with regard to references is that it's all the bullet points that relate to references are all should instructions, and at the front of KCSIE will tell you that where it says must, it reflects a legal requirement, and where it says should, it should be complied with unless you have a very good reason not to do so. So our advice is always comply with should instructions unless there is a good reason to depart from that. And if you depart from it, be able to explain why you've done so. So the first issue that's come up is paragraph 203, which says that schools should obtain references before interview. Now, this is just a much more categorical statement than was in the previous version of KCSIE, which said schools could obtain references before interview, and this would allow you to discuss those references at interview. It's now a much more categorical statement. So again, does it have to be followed? Well, as I've just mentioned, it's a should instruction, so you should follow it unless you've got a good reason to not to do so. What would be a good reason here? Well, lots of schools take the approach of asking for references before interview for teaching staff, but not for support staff, or not for those staff who are joining from outside the education sector. The reason being, outside of education, it's not the norm to ask for references before a person is interviewed, and that has been accepted as accepted practice by inspectors over the years. Now, we don't know quite how that's going to be inspected going forward, and none of the inspection literature gives us any guidance as to how that will be looked at. Another good reason that's come across that we've come across in working with schools is that there's wording in the Equality and Human Rights Commission employment code which actually recommends that references should not be taken up before interview, because the rationale being the subjective opinions in those references can unduly influence recruitment interview panels, and lead them to lose focus on the candidate and the objective elements of their application. So I think were a school to decide that actually we'd rather follow the employment statutory code of the Equality and Human Rights Commission and take up all references after interview, then in my view that would be a good reason to depart from KCSIE. As a minimum requirement, provided references are obtained before work commences, then you will be compliant with your requirements, your minimum requirements in this respect. In paragraph 204, there's now wording which says that schools should always verify information with the person who provided the reference. We've had a lot of questions about this, as to whether it creates an obligation to contact all referees to ask if they provided the reference. Well, that was previously a requirement of the national minimum standards for boarding, and it only applied to boarding staff, in that they had to contact all referees to verbally verify they'd given that reference. But that requirement disappeared in 2010, and there's been no obvious sort of inclination to bring that back. And we think, therefore, that's not the intention of that wording in KCSIE. We think that wording means that where schools need to clarify some information that's vague or insufficient in a reference, that they do so with the person who provided the reference, rather than just another person at the company or school that provided the reference. So we think it's about only where you need to clarify information in the reference, that you go back directly to that referee. We have always said that it's best practice to verbally verify whether a referee provided a reference, but we do appreciate that's also a time and resource issue as well. So best practice to do it, but we don't think it's a requirement, and we don't think this wording has changed that at all. Moving on. Just something to think about in terms of disclosure of references. So the position now is that references can be withheld from subject access requests, and this is not something that's in KCSIE, but it's certainly something that we've come across recently in working with a number of schools. Is that references can be withheld from subject access requests, and that's both the references received and references provided. But whether a reference is to be treated confidentially should be made clear in some policy documentation that you have. So we've therefore amended our reference request forms and our reference request letter in the Safe Recruitment Pack to explain that the references that the school receives will be treated as confidential. If you want to put similar information similar wording in any references that you provide if you want them to be treated confidentially. Now, what this doesn't do is give you sort of carte blanche to write anything about a person in the reference, because whilst there is this, whilst it's harder for an individual to get that information in a subject access request, were they to commence litigation, they would very likely be able to get hold of that reference in the disclosure exercise in that litigation process. So our advice would always be make sure that anything you write in a reference or anything you say verbally to back up a reference is something that you can justify and will be prepared to justify as well. And we also advise checking your staff privacy notice to see whether it covers confidentiality and references, and if it doesn't, updating that to ensure it covers how you want them to be treated. Next slide, please. Thank you. There's some additional wording here at paragraphs 206 to 208 of KCSIE about the scope of the interview. So I won't run through them all, but this is all new wording. Although it hasn't seemed particularly new to us. This has all been mentioned in a couple of serious case reviews that were published in recent years, and which we built into our safer recruitment training. But it's good to see that it's making its way into something now that's widely available to schools. So what we just say is make sure when you are interviewing that you are covering all these areas. Some of them maybe not necessarily particular questions about each area, but a number of questions that cover those areas is important. I think asking questions for candidates that require them to provide examples of their interaction with children is very useful, particularly for those individuals who are coming to you from a non-education background as well. So that will give you some information, hopefully, about their understanding of professional boundaries and how they view themselves in relation to children, as well as their skills and experience and their motivation for wanting to work with children. Looking at the bottom there, past disciplinary action or safeguarding allegations. You are and have always been permitted to ask a candidate about any disciplinary action from previous employment or any safeguarding allegations. I think the aim of the new wording, KCSIE, is really to encourage schools to discuss those issues sensibly and not to rule people out automatically on the back of them, but to take proportionate decisions about suitability once you're fixed with that information. I'd also say when you're completing your notes after an interview and your interview assessment forms, just again look at this list here and ask yourself, have we covered all the areas that we should be covering? Again, inspectors will look at files, they will see notes from the interview process. They may compare it with what's in Keeping Children Safe in Education. So look to see if you're complying with the new wording. The next slide, please. I'm only going to talk about this one check today, just because it sort of continues to cause confusion. So this is overseas teaching sanctions, and they were formerly the EEA teaching sanction check, which schools could carry out through the teacher services system. A nice, easy check that could be done online quickly and effectively. That check ceased to be possible with effect from 1st of January 2021 due to the UK leaving the EU. And we therefore thought that there'd be one less check for schools to do. That didn't turn out to be the case. And then in the middle of January 2021, the DFE introduced this requirement to obtain a letter of professional standing where an applicant had taught overseas in the past. That's now been updated in the new version of KCSIE, and it talks about when schools are obtaining overseas checks for people applying for teaching positions, they could, so it's a could instruction, different to should or must, obtain a letter by the applicant from the professional regulating authority in the country or countries in which the applicant has worked, confirming they have not imposed any sanctions or restrictions, and they are not aware of any reason why that person may be unsuitable to teach. That's paragraph 262 of KCSIE. So you'll notice it's slightly different to the wording in the 2020 version. What I'd say about this is that I mentioned it's a could instruction, so the status of that is slightly uncertain. But what I would say is, if you would have carried out an EEA check on a person, then you should be doing this where it applies. Where does it apply? Well, it applies. It's limited to teaching appointments. So only those people you're appointing to carry out teaching to a teaching role. But it's not limited by time or by geographical scope. So you'll need to look at an employment history of an applicant for a teaching position to determine whether they have worked as a teacher overseas at any time in the past. And if they have, then you should be asking them to obtain a letter from the professional regulator of the teaching profession in that country about any sanctions or restrictions that may have been imposed, i.e., can they provide some information that they've got a clean bill of health in that respect from that country. Now, what we found in advising schools over the past couple of months is that it's been very difficult to obtain this letter for a variety of reasons. And I don't yet know of a school who's managed to obtain one. And so what we said is ask the applicant to keep evidence of their attempts to obtain this letter. And when they effectively hit a brick wall in that process, to provide you with all that information, you can then take a decision on whether you want to appoint them based on that and all of the other information from the recruitment process. And that's all permitted under paragraph 264 of KCSIE. This is something you carry out in addition to other normal overseas checks, and it's about suitability. So a sanction imposed somewhere else wouldn't prevent a person from teaching in a school in England, but it certainly would go to their suitability. So that's why you're trying to obtain that. Can I have the next slide, please? I just wanted to finish by looking at changes to part 4 of KCSIE. I'm not in any great detail, but just the fact that it's been now split into 2 parts. So we've got section 1, allegations that may meet the harms threshold. But of course, part 4, prior to this version, was all about allegations that meet the harm threshold. But part 1 now is about allegations that may meet the harms threshold. This threshold hasn't changed, but you do need to consider whether you're working with section 1 or section 2 of part 4 by looking at this part, looking at whether a person's conduct has met the harms threshold. So that's whether a person's behaved in a way which has harmed or may have harmed the child, committed a criminal offence against the child, behaved towards a child or children in a way that indicates they could pose a risk of harm, or behaved or may have behaved in a way that indicates they may not be suitable to work with children. The point I wanted to make here is that there is quite a low threshold for the definition of harm within the Safeguarding Vulnerable Groups Act. There's wording that says that harm should just be given its normal everyday meaning. So there's no technical legal definition of harm. So it's something that we would consider harm in a normal everyday context. And I think that makes the definition or the threshold quite low, because you wouldn't want to be ignoring something that might amount to harm. If you also look at that 4th bullet there, that doesn't even mention harm. So it's just talking about a person who has behaved or may have behaved in a way that indicates they might be unsuitable to work with children. So it takes harm out of that definition. So it's a very low threshold for following section 1. And of course, if section 1 has to be followed, then we're talking about referring matters to the LADO. I'll just have the next slide, please. What we've got in section 2 is that these concerns that do not meet the harm threshold. Now, I've just said I think that harm threshold is pretty low. So what are concerns that don't meet the harm threshold, and how should you deal with them? Well, it's not particularly helpful, the wording in KCSIE, and I think this area is still very much developing. Firstly, 406 says that schools should have policies and processes to deal with concerns and allegations which do not meet the harm threshold. So you'll need to think about implementing a process. I think a lot of schools are still getting to grips with that, and that's fine. I think my advice at the moment would be don't overcomplicate that policy or that process. The priority is about getting a message to staff to identify and report low-level concerns. Reporting should be to the head, and from there, really, the head, probably with the DSL or deputies, will determine whether the harm threshold has been met or not. And if it's not been met, it'll be for the head and those senior staff to determine how that issue will be dealt with. And I don't think that policies really need to cover in detail how something will be dealt with once it's been identified as a low-level concern. But it's all about encouraging staff to identify, report those concerns, and know that they will be dealt with by senior staff. Some of the issues for me come in identifying what a low-level concern is. So we have examples in paragraph 410 of KCSIE, which are really unhelpful in my opinion. So they talk about low-level concerns, including being over-friendly with children, taking photographs of children on their mobile phone, engaging with a child on a one-to-one basis in a secluded area or behind a closed door, or using inappropriate, sexualized, intimidating, or offensive language. So for me, they're all pretty serious issues that you would automatically have contacted the LADO about previously. They'd all be fairly clear breaches of your code of conduct. And I can certainly recall having advised schools on the dismissal of staff in all those circumstances. So I think those examples there, it would be unhelpful to reflect those in a low-level concerns policy. And I think what we should be doing is encouraging staff to say that any concerns that look to be inconsistent with our code of conduct or which otherwise cause you some concern should be reported. But I'd certainly avoid using those examples in that policy, because I think it will cause some confusion about what's low level and what's serious. So then the key for me, getting staff to report any concern, having a good code of conduct, and then where does that low level concerns policy sit? Well, keeping children safe says in your staff code of conduct and safeguarding policies. But I think I'm increasingly coming around to the view that it might be helpful for schools to have a separate policy which deals with allegations that meet the harm threshold, and at the back deals with how low level concerns are dealt with. But I think our thinking in that respect is developing at the moment, and it'll also be interesting to see how this develops more generally in the sector. So I think that's the end of my slides. I think we can move to the next one, please. Thank you. So do we have a number of questions?
We have lots of questions, Richard. Whilst you're reading through some of them, I'm going to tackle some of the recognition agreement questions. So the first one here is, if you can't reach agreement with the union for the wording of the collective bargaining agreement, can they then decide to use the statutory route? Effectively, yes, because if you're in voluntary discussions and that's not bearing fruit with coming to an agreement, even if it's just in respect of the wording of the agreement, then you could stop there, and then yes, the union will have the right to then go through the CAC route. If you're still wanting to engage but wanting to have somebody arbitrate, you can even turn to ACAS at that point. So ACAS could then arbitrate to try to reach a resolution on the collective bargaining agreement. Another question is, we already recognise the NEU, and now the NASUWT is requesting recognition. What can we do? Well, effectively there, if you recognise a trade union already, then effectively you can prevent other unions from seeking recognition, because once that one recognition agreement is entered into with that union, it prevents others from then also requesting recognition. So some schools have used it tactically in choosing which unions they do want to engage with. So that's one to bear in mind, that if you do have a preference over which union you want to engage with, then perhaps have that conversation far sooner. And then one final one, just for me to finish on, is we are varying slightly the length of the teaching periods, and this impacts when teachers will finish their day. But the unions have now got in touch because the common room is so very upset, they are demanding that we halt our consultation and want to engage in discussion. Now, I suppose I just need to unpick that a little bit. So if you're already in the flow of having consultation about any sort of changes, can the unions prevent you from continuing with that conversation? In essence, no, because your obligation still is to your staff. So if you do want to continue, then you've got the right to do that, and you can still continue to have that dialogue. Here, what we don't know is whether or not the unions have formally requested voluntary recognition, or if there's just been discussion about this is what we will do. If they haven't, then you just continue as is. If they have, I suppose tactically you need to decide how far down the road are you, when might you implement the changes, and can you still have the parallel conversation, because that is a possibility. Richard, if I pass over to you.
Yes, thanks. Right, I've got a few questions. So the first one is, with regard to interviewing, does only one person or all people involved in a panel need to be safe recruitment trained? Well, the wording on that has always been that at least one person on a panel is safe recruitment trained, and if a person's interviewing on their own, that they are safe recruitment trained. The next question is, essentially, if you are safe recruitment trained, is it valid for 2 years, or should it be renewed annually? There's never been a requirement to redo safe recruitment training at any particular interval. So I think it's just a case of ensuring that you are, your training is being kept up to date at a reasonable interval. And of course, if we get changes like we have this year, then I think that's a key trigger to go and do safe recruitment training again. One comment that there's a new check requirement to see birth certificates. So I mentioned that there were no new checks in KCSIE. Seeing a birth certificate is part of the verifying identity check. And it talks about it being best practice to ask an applicant to provide their original birth certificate. The rationale being for that it should contain their original name, therefore making it easier to identify whether a person has told you the truth about whether they've been known by any other names in the past. But it's only best practice. We have built that into our documents, and we said we'll ask all applicants to bring their original birth certificate and then wait to see if they can do that, or whether they have an explanation for not being able to do so. If they can't produce their birth certificate, then it's not a bar to appointing a person. It just goes down to whether you consider that explanation to be reasonable. Next, if DBS declaration is not included to the shortlisted panel, can we leave the declaration on the application form? And then it says, but if all roles are exempt from the Rehabilitation of Offenders Act, can we still ask the question about criminal records on the application form? Well, as I mentioned, you're entitled to ask about criminal records on the application form because all of the roles are exempt. So it just comes down to whether you're asking for that information from too wide a group of people. So the argument would be, well, why do you need to know it about all applicants when you can ask all shortlisted candidates before interview? Now, it's not been tested in any way, and I'm not aware of any Information Commissioner's Office decisions on this. So it would really come down to, I think, whether you could justify continuing to ask that question. And I'm sure you could say it's because we want to make sure that we've got suitable individuals applying for roles at our school, and it's a further example of deterrence at the earlier stage. So I think you could argue it both ways. One question, whether our template documents incorporate the KCSIE 2021 changes. Yes, they do. As I said, we already had a lot of it in there because we hadn't changed them a great deal from the older, more comprehensive guidance, but they do incorporate the changes. Regarding references, if an applicant expressly asks you not to collect references, should we honour that request? Well, yes, I suppose it's asking for data about them. If they say they don't want you to contact a referee, then you shouldn't do so, but you should question whether you want to appoint that person. If it's an express request not to contact before interview, then that's really a policy decision for you as to whether you insist on doing that as a condition of proceeding with their application. Another question: in the scope of interview, should you not cover prevent? Yes, you can ask questions about preventing the interview. It's just not covered in that new wording in KCSIE, but yeah, you don't have to, but you can do so. Do we have a low-level concerns policy? Not at this stage, but we are developing it and discussing it internally. So we will have one. We will have one soon.
I think, Richard, if you take one more in view of the time, what we will do though is answer all these questions, and when we send out an e-bulletin letting you have the slides, etc., we'll make sure that you've got the answers to these questions as well.
Okay. There's one question here about should the birth certificate be added as an additional column on the SCR? No, on the SCR, all you need to do is to document whether you have verified a person's identity. You don't have to verify the way in which you did it. And just to clarify my point on whether you can ask questions about criminal records in the application form, you can legally ask for them, but it might be that doing so is considered disproportionate from a data protection perspective, but we don't have a definitive answer on that at the moment. So you may be able to continue doing so. You may then have to just sort of justify why you continue to do that when there's new wording in KCSIE which says move it to a shortlisting form. I think that's all of them, isn't it, Nassim?
It is. There are plenty more there. We'll make sure that we provide the written answers when we do circulate the slides. But at this point, thank you so much all for joining us, and we'll be sure to follow up with the slides in due course, and Amy will have that in hand.